Okay, thank you.
So, hello everyone. Welcome to today's CIF seminar. My name is Ezgi Eren, and I will be moderating this session. It gives me great pleasure to present today's speaker, Irmak Erdogan Petar. Currently, Irmak is a postdoctoral researcher at KU Leuven CITIP. She specializes in criminal law and data protection, particularly in criminal profiling and risk assessment technologies. I am one of the lucky people who gets to call her a colleague and a friend and who gets to directly work with her. But she's not only these adjectives, she's also a lawyer from Istanbul Bar Association. In 2014, she started working as a research and teaching assistant at the University of Galatasaray and at the Criminal Law and Procedures Department, where she also obtained her PhD title. During her PhD, she was quite active. She had 2 research stays abroad, one in Switzerland, one in Italy, for a total of 1.5 years, and she was awarded the prestigious Swiss Government Excellence Scholarship to do her research in Switzerland at the University of Basel. Irmak completed her PhD in 2022. Her thesis is titled Artificial Intelligence and its Implications on Data-Driven Criminal Justice. It is incredible. I had the chance to read it as well. It was a huge pleasure, and I recommend it to everyone, though it's in Turkish, so maybe Irmak will consider translating it in English in the future. Today, Irmak will present predictive policing and the defense rights against criminal risk assessment. So please, Irmak, go ahead.
Thanks a lot for the kind introduction, and thanks everyone for being here. Maybe for some of you, some of the slides might be familiar because we talked about them before in other seminars too. And today, as we said, I will talk on predictive policing and the defense rights against criminal risk assessment. So I will quickly give an outline of the speech. First, I will try to contextualize surveillance. Then I will raise up some problematics, research questions, and I will introduce the profiling tools and explain relevant principles and laws in criminal procedures. And finally, I will talk about relevant data protection regulations and come up with a conclusion. So this is not in the presentation mood, I guess, because this kind of pre-caps and static should have appeared later, but that's fine. So I will start with a quote from Kafka. It's about the character K. K was living in a free country. After all, everywhere was at peace. All laws were decent and were upheld. Who was it who dared across them in his own home? So it's about the feeling of living in a democratic country where actually people don't get to question sometimes the importance of things like separation of power and other things. But then with the intrusive technologies, without really noticing, we reach a point where people are starting to be on the lists shown by profiling tools, which you see on the screen. And also they started to become a suspect without knowing why. So today I will introduce these technologies that you see on the screen and try to find out what we can do to enforce more rights for the suspects. To contextualize surveillance, I want to start with the PRISM model, panopticon. Actually, the idea of the perfect surveillance started in the 18th century when Bentham tried to build a prison system, which is very efficient in the sense that you would need less guards and you would have all the prisoners under surveillance efficiently. He put the guard in the middle and all the prison cells were in circular shape so that you can observe everyone and what they are doing, whereas they wouldn't know if the guard is still there, if the guard is still checking on them, but even the feeling of being observed constantly changed their behavior and lead them to auto-censor and auto-discipline. So when we take this model to a more general level and think of all these CCTV data collection on the internet and being observed or not knowing if we are observed, it's of course has an impact on our behavior. And when we switch to problematics that I asked in my PhD thesis, how do profiling methods differ from other criminal procedure measures? Because the traditional criminal procedure measures are like search, communication interception. They are foreseen by law and they are limited. Sometimes they are even limited to enforce for certain type of crimes. But how do profiling differ from them? And does really the use of profiling technologies meet the principles of criminal procedures law? And the third question, we of course have some regulations in for data protection. Can we really implement them in criminal procedures? And would it make the rights of suspects stronger? And the final question, even if we do all of this, do we still need a separate regulation for the use of profiling tools within criminal procedures? So before introducing profiling tools, I try to define profiling. It's not only me, it's from Mireille Hildebrand. She said it's using a vast amount of data to discover patterns that will have some predictabilities. So the underlying assumption is if we reveal, we can reveal some kind of hidden order from past data and provide a kind of oracle that will predict how people will behave in the future. So I divide the profiling tools into two, profiling 1.0, profiling 2.0 tools. The first ones, as most we know here, but maybe if there's audience from other fields, they might not be familiar with them. They try to predict the next crime scene. And they use data which are based on criminological theories. Like if there has been any crimes committed in that neighborhood before, it is actually important because according to the near repetition theory, some crimes like burglary, theft, they happen to occur again in the same neighborhoods, in the same apartments, because the perpetrators know the fragility of the neighborhood or of the victims. And of course, economic and social fragility of the neighborhood matters too. If there are conflicts in the neighborhood, they may give rise to crimes. And we can also look at the broken window theory, which is about if you leave a car with a broken window in the neighborhood and if you leave it unattended, then you see that suddenly graffitis started to occur on the car, then everything in the car is stolen. And if you still don't interfere, you see that little petty crimes start to occur in the neighborhood. So that's why the petty crimes and the negligence in the neighborhood matters as a data set. And of course, sometimes simple things like season of the year, time of the day, they also give rise to crime. So collecting all this data, where the next crime scene is going to be, it's at the first look, it looks very objective, this kind of data that we collect, but it depends on what you do afterwards. So you have a risky neighborhood, do you send law enforcement there directly? And if you do so, and if there's more control, more search on people, of course, there will be more data showing that, I found something, I found another petty crime. And then this will feed the profiling tool, the algorithms. And again, of course, it will self-fulfill the fact that this neighborhood is very dangerous indeed. But in return, it makes people encounter the police more. It makes them feel that they are segregated from society and they're always under police force. When we look at the profiling tools 2.0, you can see that they're in use in the USA, the Compass algorithm, Key Crime in Italy, CAPS2, and Siri, which was actually, there was a case in the Netherlands and they didn't find Siri. They came up with the conclusion that it interferes with the right to privacy intrusively and without a foreseeable law. But other than Siri, the other technologies are still in use and they try to determine who is going to commit the crime. So they want to make guesses about the perpetrators, possible perpetrators, by taking into account data like the economic situation, does this person work, how about his family, how about his education level, does he have ex-convictions, like very different diverse data sets these kind of technologies use. And I want to zoom into two of these tools. LSIR is very, very much of course, they use like 130 different data, but I chose the interesting ones. The first one for LSIR is okay. It uses criminal history, but reliance on social assistance is a weird data for me, because there could be, of course, times that people lose their jobs. They can rely on social assistance. What has anything to do to show that this person is dangerous to the society? And interaction with authorities and peers, like if as a student you were a student who challenges the teacher a lot, who was an outcast, not going along with your peers, this is taken into account. And the last one is also a funny example for me: dissatisfaction with marital situation, also what has anything to do with being dangerous to society. So when we look at Compass, we also see similar ones like history of violence, criminal associates is also interesting, because if you have connections with criminals, you can live in a neighborhood where you're next to them, your uncle could be a criminal, you can have some friends on Facebook who have been charged before, and so on. Does it show that you are personally more prone to danger? And financial problems, we see similar data on this case. And use of leisure time. So if you are just a lazy person doing nothing and not interacting with society, it's probable that you are not good also in long term for society. And criminal history in the family is really crucial not to use for me, because in criminal law, it's really important that the responsibility is not collective, it's individual. So the criminal history in the family shouldn't be in database. It's my opinion, of course. And when we look at the results of using this kind of data, of course, in the United States, there's still segregation between Black people and white people, in the sense that their right to access to education is different, their work conditions and everything is different. And if we combine all this data, the results are they are found more dangerous than the white people. And is it really true? Does it really also correspond to reality? We can also ask that. Maybe it shows something. But in the Compass, the case against the Compass showed that there are still flaws in these technologies. It means that we should concentrate on false negatives as well as false positives. What does it mean? In the first picture, you see a white man who is shown as not dangerous. So it's a false negative because he committed armed robberies before, and even though his risk was pretty low, he committed again. So it's a false negative which let this person go and reoffend. And on the other hand, false negatives are also very bad for criminal procedure's sake, because it means that you wrongfully interfered with someone's right to security and liberty. So in this case, she really committed a misdemeanor. She was found highly risky, yet she didn't reoffend. So what can we do about, how do we deal with this within criminal procedures? First of all, I should underline that the traditional measures in criminal procedures have to fulfill some of the criteria, like reasonable suspicion, judicial control, and being transitionary. When we focus on reasonable suspicion, it means that we focus on the act, not on the perpetrator. We don't deal with the character of the perpetrator. We look if there's an action which is against, which is defined as a criminal act. So then we show that this criminal act is committed by the person relying on the objective facts, like it can be witness statements, a camera footage, or DNA, and totality of the circumstances will show us that this person committed the crime. Whereas in automated suspicion, we don't look at the facts which connect the action with the perpetrator. We rather look at the data about the perpetrator, and we assume that just because what he did in the past, he will redo it, or he might have done the action which is interrogated. This automated suspicion, as I said, doesn't rely on the facts, doesn't rely on objective indicators, but they rely on the correlations within data, and correlations on the data which leads you to be in a group, and then you're responsible for having affinities with the same group. So if you are not responsible for the acts you committed individually, you are responsible for what you did before and how you are similar to other people. So it leads to a collective responsibility, whereas reasonable suspicion must be particularized. And of course, there's always a judicial control. When you want to have a search warrant for someone, the judges determine if there's a really reasonable suspicion, if it's really necessary. Whereas in profiling tools, when you have like suddenly a risk alarm, the police goes there directly without being under surveillance. So it's up to the police in a way how to react to these red alarms. And more importantly, when your house is searched, then the law enforcement goes out of your house. When you're arrested thinking that you might get rid of some evidence and the evidence is found and secured, then you're out of jail. And these kind of measures are transitionary. Whereas with the profiling tools, when you are listed, it's like a permanent record. You can get yourself out of the list if you're aware of it, of course, and if you can object to it. But then it's like snowballing. You can find yourself in another list, suddenly not being able to find a job. You can find yourself on another list where you cannot take a flight. So how do we prevent this snowball effect, which makes people segregated from society in a way permanently? So, but when we look at the criminal procedures and how we should deal with profiling results as evidence, we have some principles which might still protect the suspects. We all know presumption of innocence. We should underline that it starts from the point where you are suspected. So we can even enlarge it to investigation period, says the European Court of Human Rights. And then it extends till the decision about you is final. So it's not only about the first instance court that decides on you that the presumption of innocence is over. It's the second court when they say, okay, this judgment is right. Then you can be assumed as guilty. But this kind of tools make almost a presumption of guilt. Like in the character K in Kafka's trial, you are suddenly in face of being on a list and you try to prove otherwise. So it doesn't really converge with the principles of criminal law. And when it comes to equality of arms, it means that, of course, as a suspect, you have whole law enforcement looking for evidence and whole state, in the name of state, a prosecutor and a judge. So what are your tools? How can you fight against it? You should have at least kind of equal tools. And right to defense is one of the most important points which ensures this equality, because you have the right to be informed, you have right to contest the accusations, and anything that is brought against you in the case, you should be able to be aware of it and be able to answer it before the court. So when we think of the profiling tools, of course, we have technical experts here. They don't all have to be depending on self-learning algorithms. They can be also depending on more followable structures where we know which kind of data are used and what percentage they impacted the results. But if you use self-learning algorithms, then even the person who created the software wouldn't be aware of how the algorithm came up with the conclusion. Like if suddenly a person who eats spaghetti is more likely to be risky, then how did we come up with that conclusion? We wouldn't be able to even follow the reasoning. And then the right to defense would be useless because there is a tool that you don't understand, that the judge doesn't understand. And how can you have a right to defense then? So we see, since in the US, these tools are aggressively used, we see more case law in the US, which tackles the issue of right to a fair trial. So in the State Loomis case, which deals with the Compass tool, we see that the judge says, first of all, the suspect said, my right to defense is limited because the algorithm and how it functions was not shared with me. What kind of data was used wasn't shared with me. So how can I contest it? And the other part said, yeah, well, it's protected by state. I'm sorry, I forgot the word. License. Sorry, it's protected by license, and we don't have to share. And the judge said, "Okay, leave this discussion aside. We think that the right to a fair trial is not infringed because there were other evidence showing that the person has committed crime." But the judge doesn't go into if this kind of tool should be used in criminal procedures or if it has a potential to infringe the right to a fair trial. in the Melanchik case, there was a tool, LSIR, which is used. And the court said, well, these are very scientific tools. They are really proven to come up with correct results. Why wouldn't I use it? If the person is risky, why wouldn't I use it to arrest the person? Whereas on the same tool, there is Roth State case, which tells quite the opposite. Well, these tools are depending on collective group profiling, and you are trying to judge a person and decide if the person has committed a crime. If the person has a risky character, if the person is not nice at all, what has anything to do with the crime committed? So these kind of tools create bias on the judge, thinking that this person might have committed, but criminal procedures doesn't function like that. So you should be careful with these tools and should not use them at all if it's going to create bias on judges. So you see that any contradictory case law, and we should come up with a solution for that to unite the decisions. And criminal procedures principles are not sufficient to enforce similar type of decisions. But then how can we use data protection rules within criminal procedures? I mean, here the audience knows all of these rules, so I will quickly go over them for maybe if there are any engineers or from other people from other faculties. Within the Council of Europe, we have Convention number 108, which has rules for profiling, and within the European Union, there's, of course, General Data Protection Regulation and Law Enforcement Directive, which I will focus on. And in order to enforce the protection foreseen within the general GDPR or Law Enforcement Directive, first, of course, we have to have personal data. It seems very easy. Okay, any information relating to an identified or identifiable person. But what is an identifiable person when it comes to especially criminal procedures? So if all means reasonably likely to be used, the costs, amount of data, available technology allows the person to be identified at the end, we have an identifiable person. But I think Breyer case is especially important for criminal procedures because it says if you have legal means which allows your police enforcement to have access to internet service providers, to have easily collect data from other sources, then they can connect this data and the person becomes identifiable. So if you don't have legal rules which prohibit the access to data by law enforcement so easily, then it means legal means allow them to make the person identifiable. So we should think of the notion of personal data a bit more broadly when it comes to criminal procedures and should enforce the protection of personal data protection rules. But which one are we going to use? So if we are collecting data, processing data for the purposes of prevention, investigation, prosecution of a crime by a competent authority, both these conditions must be met. So the competent authority being law enforcement, the prosecutor, the courts, if they are collecting data for the purposes of investigation, we go to Law Enforcement Directive. If any of these conditions are not met, if the private companies are collecting data for the prosecution of crime, for detecting a criminal, then we go to GDPR. But since our time is limited, today I will just focus on the Law Enforcement Directive and the profiling regulations within it. So Article 11 is about profiling, and it says, member states shall provide for a decision based solely on automated processing. First, there should be a decision based solely on automated processing. But I repeat my question, if the judge has no clue about how this algorithm works, and if the judge controls and decides, so if there's an intervention by a human being, is it a real intervention or is it still solely automated processing we are talking about? And this kind of decision made solely on automated processing should have an adverse legal effect or significantly affects for the person. So of course, if you are searched based on these tools, it has a legal effect on you. So it's maybe a bit easier. But this article says this kind of decision making, creating adverse effects and based on solely automated processing is prohibited. So this is a prohibition article. This is unlike GDPR. It's more clear about the prohibition. The only condition that it wouldn't be prohibited is by a union or member state law, it is allowed. But this law should be so precise while allowing it that it should have at least a right to obtain human intervention, and it should enforce and safeguard the rights and freedoms of the subject. So there's only one way that you can do it, by a foreseeable law which guarantees rights. But how about the discrimination part? What do we do? And are there also other regulations regarding that? Yes, the second part says that you cannot base your profiling and decision-making process on special categories of data, meaning that on the religion of person, gender of person, and so on, unless, but there's an exception, you have suitable measures to safeguard the data subject's rights. So it might be possible even to use this kind of data as an input data. But the problem is sometimes you don't use this kind of data, but at the end, the algorithm comes up with the gender, also with the religion or other sensitive data-based comments, not comments, but results. So what do we do then? So the third one deals with that and says profiling that results in discrimination should be also prohibited. So you don't only look at the input data, you should also look at the results of profiling, and if it results in discrimination, it should be prohibited. I find especially this third part very important because it's also a bit different than GDPR Article 22. It is more precise that you should focus on the results too. And of course, we have right to information in the law enforcement directive, where the data subject can ask the purposes of processing. Yes, you're using this tool, but why? And the legal basis. Do you have a legal basis for profiling tools? The storage period, how long are you going to keep it, should be shared. And of course, right to access is what kind of categories of personal data is used. So unlike the case in the US, here it's possible to ask, what are the categories that you feed the profiling tools? And to whom did you disclose this data? To whom you shared this data with? And it's also crucial that where did you get this data? What is the origin of this data? All these rights are really crucial, and we should integrate them in criminal procedures to also enforce the equality of arms. But of course, there are limits because we are talking about an investigation. So if asking for this information obstructs investigations, interferes with preventing criminal offenses, or threatens public security, it's likely that you might not get an answer or your answer might be limited. But there is also another interesting mechanism in the law enforcement directive, which is different than GDPR, is even you receive an answer, sorry, we can't give you further information. What you can do is you can go to the supervisory authority, and the supervisory authority, based on Article 17, can check if the law enforcement did it legally in a lawful way, that they limit your rights to information if it was necessary. When they check, then they can get back to you, to the suspect, and say, yeah, they were rightfully to do so, or it wasn't right. So you see that the obstacle between the suspect and the law enforcement authorities is that they don't want to disclose this information for the sake of interrogation, investigation. But when there is the data protection authority in between them, it outbalances the situation, and then you have a third solution. I really think we should underline this article more and make use of it in investigations. But with prosecution period, it's a bit harder because the states don't have to allow the judges to be under the control of data protection authorities. It means that you can make further laws which allows data protection authority to check the data collected by the judges, but you don't have to do that. And it might also create a confusion between the separation of powers. Like, can you really check on the judiciary is another question. And I haven't seen any law which allows a data protection authority to check with the judges or with the courts. My conclusion is, first of all, before trying to regulate AI, maybe we should look at how we use AI and how we enforce it. Should we really enforce it to eliminate criminals, or is it possible to eliminate all criminals of the world, or is it a human rights friendly aim, or should we enforce more like economical and social solutions to the problems that we observe by these algorithms, like these risky neighborhoods? What else can we do than just sending them law enforcement? So we shouldn't think of AI only about constraints and how do we enforce public security, how do we control people more, but as a means to come up with more solutions, come up with more information, but then use it to establish a human flourishing. And enforcing existing data protection rules within criminal procedures is, as you see, very crucial because they make the right to fair trial become true more precisely. But of course, they have also limitations. First, we should be talking about personal data, and of course, there are limitations within GDPR and law enforcement too, law enforcement directive too. That's why it's really crucial because they are tackling with individual rights in a way. But if we are going to use these tools in criminal procedures, like we have regulated search, home searches, interception of data, we should also regulate in more general way profiling tools. So we really need to have new rules which ensures foreseeability and further safeguards to use of profiling in criminal procedures, meaning that under what conditions we can use them, what kind of data should be used, and what do we do with results? What is their evidential value? Is it enough to create a reasonable suspicion or convict a person? If it's not, maybe it should be also stated that you need further evidence supporting the profiling results so that all the judges can come up with the similar solutions. And yesterday we had a perfect PhD defense. It's also mentioned that the discrimination that's coming out of these profiling tools is not only gender, religion, it's becoming more complicated. We see a stereotyping of people based on their social interactions, their social economical status. So maybe we should also think of larger rules which prevent this kind of stereotyping in the first place. So thank you very much for your patience. I hope I could make it a bit clear. And if you have any questions, I look forward to answering them.
Thank you very much, Irmak, for this.